This project was made possible by a grant from the Virginia and Alfred Harrell Foundation and all of SJV Water subscribers. Hello, I'm Lois Henry, editor and CEO of SJV Water, and we are continuing our video series exploring how the Kern River is divvied up. Our last video explained how rights to the majority of the water, about 80%, are held by local agricultural water districts, with about 20% going to the city of Bakersfield. But there's a legal principle that could impact all those various other water rights, contracts, and agreements. It's called the public trust doctrine, and it's the crux of a lawsuit filed by Bring Back the Kern, Water Audit California, and several other groups against the city of Bakersfield in 2022.
Sure. Public trust doctrine in California, it's a common law doctrine that actually was adopted or held over and inherited from Old English law when the United States was first formed and when California became a state. And it even goes farther back than that. It goes back to Roman law. England got it from Roman law way back when. The idea behind the public trust doctrine is that the certain resources, certain natural resources are owned by everybody in the state. They're not owned by individuals. They can't be privately owned. And water is one of them. The state is the trustee of those resources on behalf of the public. So one of the things about the public trust doctrine is that it's not an absolute block of using water. It's not an absolute prohibition against using water. The public trust doctrine just requires, it's like a look before act doctrine. You have to consider the impacts before you can take an action. In 2022, our coalition filed a lawsuit against the city of Bakersfield. Bakersfield controls and owns and operates 6 diversion dams in the city of Bakersfield. All these diversion canals that take the water and send them to different users, primarily agriculture, area farms, agriculture interests. So our lawsuit is against the city for its operation of those dams. And on the public trust, what we're saying is that when you operate, hey, city, when you operate these dams, you need to be thinking about what impact you're having on this trust resource. You're the trustee for this particular resource in this particular area, because this is your ward. This river is your responsibility, and you're managing it, and you're taking care of it on behalf of all the people. And what the city of Bakersfield has done is it said, oh, there's a bunch of contracts that were signed 100 years ago. We're powerless. We can't do anything. We have to give all those people all the water of the river. And we're going to take our cut too. We're going to take our water that we want. And there's nothing we can do. Our hands are tied. Sorry, we have to dry the river up 99% of the time. And what our lawsuit is saying, nope, actually the public trust doctrine is your first step. That's above everything. And so this lawsuit is seeking to get the court to order the city of Bakersfield to recognize its trust duties, to protect that trust res, the river, and then to recognize that it has to consider its impacts to the river before it starts before it diverts the water. It's supposed to look at these different users and say, okay, is there a reasonable way that we could mitigate the harm to the trust res? Or is there a reasonable way that we could avoid the harm to the trust res and still accomplish some of the goals that we're looking for? Is there a way we can balance some of these interests? The city's never done that. It has declared that these contracts are supreme. It's powerless to fight the contracts. It's going to follow the contracts every single time. It's always going to give the water away, no matter what the impact is in the trust res. And what we're saying is, hey, city, you need to look at the impacts. And if you can avoid or mitigate those impacts, if feasible, and feasible is a pretty low standard, it's not that big a deal, then you should do that.
The trial date for this lawsuit is now set for February 2027. Meanwhile, the California State Supreme Court is reviewing a portion of the case. The last time the High Court ruled on an issue involving the Kern River was in 1886, and that ruling set the basics of California water law. So as always with the Kern River, stay tuned.